I bring about harm. In other words, I violently lash against someone, and at the end of the day, I do not comprehend that the primary goal is going to be that of harm. However, when I am lashing out against somebody and it is predictable for me, and I know that the result of my actions will definitely lead to harm, then I am guilty of a crime. Okay? I know for a fact that if I shoot you, you will die. I still go ahead and shoot you. Okay? There's no way I can go to court and say, no, I was just warning this person. How do you warn the person when the gun, the shot has already been fired? Okay? So you can't warn a person in that manner when it has already hit their body. So you can't go to court and say, no, I was just warning this person, because you know that it is very much predictable for you that your actions will definitely lead to this sort of harm. So actual knowledge or belief, blindness or willful blindness, this is what constitutes knowledge. Actual knowledge, you know for a fact that if I do this, harm is going to come. Or you believe that if I do this, what is going to lead is this. Or you willfully are blinded, or you willfully blind yourself, okay, to see the facts, then you will definitely be found uh, guilty of that particular offense. Remember, under in criminal law or in law, basically, ignorance is never a defense. Okay, ignorance is never a defense. Can come and claim ignorance, especially when facts are clear and it is reasonable that your actions could have led to this. So you can kind of say, oh, no, I didn't know, but that what I'm doing is going to lead to this. So you might want to look at section 318 of the Penal Code that talks about having knowledge of committing a particular offense. You might also want to read, for emphasis purposes, the case of Dixon, uh, Sembaoke, and the people 1988 to 1989 rather. Zambello reports, page 144, which is the Supreme Court case. So basically, it talks about knowledge. So our take away from knowledge should be that you are well aware of your actions and you know certain results that will come about or the aftermath of your actions, but you just don't care. Still go ahead. Okay. You know that if you hit somebody in a certain way, you might injure them, but you just don't care and you still hit them and you injure them. So the court is going to actually conclude that you had the requisite mens rea, which has been seen via knowledge. Okay, now let's try and look at negligence. Negligence. Now, this is the most mildest form of criminal culpability, unlike the other ones that we've been looking at. Okay, so basically, negligence, just like we look at in tort, it's you failing to meet a certain standard of behavior. Okay, you failing to meet a certain standard that is required of you to keep or observe, and you just perform below par as to what you're expected to do. For example, if a child is injured because his or her caretaker failed to perform her duties, she may be guilty of criminal negligence. Okay, you're a caretaker of this particular child, and the child is injured because you failed to look after them in a manner that a reasonable parent or guardian would look after a child. You will be found liable for criminal negligence. You criminally neglected this child and becomes an offense. Okay, so it is actually you failing to meet the standard of behavior that is expected of you. So as a result of you failing to meet that particular standard of behavior, the court is going to reach a conclusion that you did have the requisite mens rea because you're expected to perform your duties to the latter or to a certain extent. Okay, so when we're talking about negligence, you may also want to look at an act that falls below the expected standard of a reasonable ordinary person. Okay, so this simply means that you do an act of which a reasonable person, under the same conditions, would have done something else, but you can also be found liable for negligence. criminal negligence that is. So failing to keep the standard at which you are expected to do. Okay, relevant. This is relevant in cases like manslaughter cases where the duty of care is owed. Remember, manslaughter is like after murder. Murder is the highest thing you have manslaughter. So when you come to manslaughter, it means that you are lacking a certain prerequisite element for murder, and that element is the malice aforethought. When you go to the section 200 of the Penal Code, you're going to find out that when you are defining murder, it talks about the unlawful killing, or which you must also have malice aforethought. Malice aforethought is simply the intention to kill. So killing on its own is not murder, but when you have the requisite malice aforethought, then you are going to be found guilty of murder because you have the intention to kill this particular individual. However, when you do not have the intention to commit murder, when we cannot prove malice aforethought, but the person has still died, what the court is going to be looking at is that you have then been found guilty of manslaughter. Okay. It may not always alleviate you from a certain, except where you provide defenses that completely exonerate you from specific offenses. I won't delve much on that because we're going to look at them. I think towards the end of this of this course, we'll be looking at defenses and how to bring about defenses. But just to give you a hint, there are defenses that exonerate a person from liability of an offense. In other words, offenses that completely remove you from being found guilty of an offense. And then there are defenses that lead you to having a lower sentence of a particular offense. Like manslaughter, it is a lower sentence of murder because you've lacked a requisite ingredient of murder, and you've provided certain facts,
Stop
you've
bringing the pen
provided
with this
certain
time.
defenses that would help you to alleviate or to bring down or reduce rather the sentencing that is owed. So under manslaughter, we're all required to perform our duties to the latter and to ensure that we conduct ourselves in a manner that does not harm another person. But when we do not follow up through to that specific requirement, we fall under the duty to care, hold under criminal law, and it becomes criminal negligence because we've neglectedly failed to act in a manner in which we're supposed to act, or care in the manner in which we're supposed to care. So these are the cases. Just talk about criminal negligence. You might want to look at them. ARA, Domako, the people, and Muzungu, the people, and Zulu. You might also want to just read these cases. They would help you very much when we're talking about criminal negligence. So if you're found, if the court concludes that there's criminal negligence, the court is going to actually then find you or convict you of a crime, and will say that then there is the requisite malice aforethought. Okay. In ending of our session, this is what we're looking at: coincidence of mens rea and actus reus. Okay, what is the coincidence? The coincidence of mens rea and actus reus is that both must occur at the same time. We can never have actus reus today and have mens rea tomorrow. They must follow each other. If possible, they must run concurrently at the same time, in other words. So we can never have you do something today and then find you be looking for another element sometime later and then come and say you've committed this particular offense. Because remember, when we're talking about mens rea, we're saying at the time at which you are committing this particular offense, you had the intention to do so. At the time at which you are conducting yourself in this particular way, you had the intention to do so. At the time at which you are stabbing, which is the actus reus, the unlawful act, because stabbing a person is prohibited. So at the time at which you are stabbing this person, actus reus, you have the intention to kill them, mens rea. So they must always flow okay, and support each other at the same time or run concurrently. So that's the coincidence that must occur at the same time. So the coincidence of actus reus and mens rea is the principle that both the mental and physical element of the crime must be present. I'm talking about mental physical elements, we're just simply talking about actus reus and mens rea. Actus reus being the physical element, mens rea being the mental element. So both must be present at the same time. Okay, this is often called the contemporaneity rule. So it's called the contemporaneity rule in that they are almost coinciding to each other, almost taking place at the same time. And because we need to have these two elements together, then we can then say that we do have a crime. So every time you're looking at a crime, you must be asking yourself, is there the actus reus? Do we have the mens rea? And did they occur at the same time? If they occurred at the same time, then we're going to say we do have a crime. So you might want to read the case of Tawo Meli and Ara, and the case of Ara and Church. So basically, what we've been trying to look at tonight is actus, is the mens rea. So from what we've gathered, we've looked at a crime so far, and then we've also said in order for us to have a crime, we need to have the two basic elements. We need to have the mens rea and the actus reus. The actus reus being the first, which must be an unlawful act. The mens rea being the second, which must be the guilty minds or the intentionality of the person when they were committing a particular offense. What was their basic intention? And tonight we said mens rea is not always easy to prove because it is seen through conduct. And the court is going to be looking at things like recklessness, recklessness, and knowledge, and many other things for the court to actually ascertain that this person did have the requisite mens rea. So most of the times always seen through conduct. Maybe you tell somebody that you're going to slap them, you're going to kill them, you're going to do that. So all that is taken into account. So the prosecutor is going to gather any blow and is going to make a case from any angle, anything that might show that you had the intention to commit this particular offense, the prosecutor will bring it on board. That's why if a prosecutor is picking up a case to go to court, not all cases that are presented before a prosecutor go to court, because the prosecutor understands that the standard of proof is high, and mens rea is mainly difficult to prove most of the times in crimes. So it's only when the prosecutor is convinced enough that he stands a very good chance that once he picks up this case and goes with it to court, he is able to establish that all the requisite elements of a crime are present, then he will then be able to move on and establish the basic elements of that particular offense. So going forward now, we're going to be looking at offenses. If we're going to look at offenses, we're going to look at other things as well. But going forward now, the penal code will now become our Bible course, because now we're going to be looking at different offenses specifically. Then we're going to be looking at what are the nitty-gritties of you establishing the offense, but always having in mind that a crime must have those two elements. However, away from having those two elements, we also look to the specific elements of a specific offense, because we're saying they vary. How do we prove mens rea in theft? How do we prove mens rea in murder? How do we prove mens rea in robbery? How do we prove mens rea in this other offense? That's what now we're going to be trying to look at as we go on throughout this course. But what is important is to have this foundation of what is a crime, what constitutes a crime. So if we're clear here, then we'll be able to move very well going forward. So this is where I end our session. Unless we have questions, then we can address those questions and then we can move to the next session. Thank you.
Colleagues, are there questions? If you can't put up your hand, you can just chip in and ask the question. I think for me, Council, you've actually preempted my question. Because you said we're going to actually discuss it in the subsequent courses, because I really wanted to know how would you prove this mens rea in all these cases. Yeah, especially that one can argue, one can argue, but how do you prove it beyond reasonable doubt? I think we are quite eager for the next topic. I think we're gonna learn a lot of things from there. I think for me, that's something I wanted to ask and comment about, but I've seen the hand from Jonathan. Jonathan, please go ahead.
Thank you, Council. Are you getting me clearly?
Loud and clear.
My question to the module. What's the difference between subjective and objective recklessness? Recklessness. Thank you.
Answer, please, you can go ahead and address it. Answer, William, did you get the question?
Sorry, no, can you please just repeat the question?
Jonathan, can you say your question once more?
And objective recklessness.
I guess you are breaking, Jonathan. Cancel, Jonathan, come again.
Hello?
Come again on the question, because I thought
the question is, what is the difference between subjective and objective recklessness?
Fantastic.
Subjective and objective recklessness. I hope I'm clear.
Yeah, loud and clear. Have you gotten it, Council William? Council William?
Yes, I have. Thank you so much for that question. So the distinction is actually in two cases. The first distinction is in the Cunningham case, and the other distinction is in the Cardwell case. So when we're talking about the Cunningham case, we're saying subjective recklessness has to do with something that you foresaw, okay, as an individual before you decided to go through with that risk. Okay, you foresaw that this would result, but you still went ahead with that risk. So the authority is the Cunningham case. Now, objective recklessness is something that you should have foreseen as an individual. You did not foresee it, but you should have foreseen that if I go ahead with this, the possibilities that I might lead to such. So you can look at the case of R versus Cardwell. So in other questions, the court is going to be saying, but you should have foreseen this. Okay, even if you as a person in your capacity, you did not foresee it. But in reasonable perspective, the court will then come and conclude that no. Despite you not foreseeing this is something that a reasonable person should have foreseen. So in most cases, at times you may not always foresee it, but you're expected to have foreseen such, or to have been reasonable enough for you to have foreseen it. But then when we're talking about subjective, we're saying this is something that you foresaw, and you can actually point yourself that you foresaw this, but you still went ahead with it. So for a proper and continued, we would advise that you read the Cunningham case with respect to subjective recklessness, and you may also read the case of R versus Cardwell, because that's what the court gave the test on what is expected of an individual when the court is to deem them to have acted recklessly in their conduct. I hope that answers the question.
Jonathan? That was a brilliant question, Jonathan. Yeah, because I can see that it resonates with the question that I wanted to ask, but I'll actually keep it because these are the next topics. It's like Jonathan tripped. He tripped. All right. Jonathan, I know you tripped. I hope you got the response before the connectivity failed you.
Yeah, I had not.
Cancel.
I haven't gotten anything. I was out.
Okay, all right. So from his explanation, he said that subjective negligence is these are something that that you foresaw, but still you went ahead to either commit a crime. Okay, and he said we can still learn more from the Cunningham case. And other cases I didn't. Of course, I picked them down there. Then the objective one is something that you should have foreseen. That is, of course, expect from the reasonable person to act in that reasonable manner. So that is the objective negligence. Unless or otherwise, Councillor William, if I haven't represented well, you can still come in.
No, you've actually talked about it well, very concise. The takeaway should always just be that subjective looks at something that you foresaw and went through with it. Then objective is something that you should have foreseen. Even if you did not foresee it, the court would have deemed that you should have foreseen such and you went through with it.
Okay, we can proceed. Unless there's a text, let me see the text. What's the difference? Okay, it's the same question. Okay, so let's proceed, Council, to the next topic.
Good evening, colleagues. Hello.
Good evening, Council.
How are you? We will start from where we ended from as of last week. We were just looking at the introduction. We were just looking at the introduction of constitutional law, and where we're supposed to begin from actually it is on the classification of constitutions. Classification of constitution. What we looked at was actually the scope. This is just a brief summary of what we looked at. We looked at what constitutional law deals with, and we explained to say that it deals with the powers and the roles of state institutions. It also deals with the relationship between the state and its citizens. It also deals with the aspect of moral and political